Hello and welcome to the Minimum Competence episode for Monday, July 28th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have A&0 Shearman delaying start dates, Section 230 shielding social media, a Trump birthright order blocked, and California backing off $15 broadband. Let's remember, in the midst of summer, even time seems to stretch and wander, and read today's legal news. On this day in legal history, July 28, 1868, the 14th Amendment to the United States Constitution was officially adopted, reshaping the legal and constitutional landscape of the nation. Ratified in the wake of the Civil War, it was one of the Reconstruction Amendments designed to integrate formerly enslaved people into American civic life. Section 1 of the amendment granted citizenship to, quote, all persons born or naturalized in the United States, effectively nullifying the Supreme Court's decision in Dred Scott v. Sandford of 1857, which had held that black people could not be citizens. The amendment also introduced two foundational legal principles, the Due Process Clause and the Equal Protection Clause. These clauses placed new limitations on state governments, barring them from infringing on individual rights and mandating that laws be applied equally to all people. The Due Process Clause would later become a cornerstone in expanding civil liberties, providing the basis for numerous Supreme Court decisions involving privacy, marriage, and bodily autonomy. The Equal Protection Clause became instrumental in the fight against racial segregation and discrimination, notably underpinning Brown v. Board of Education in 1954, which dismantled the separate but equal doctrine in public education. Initially resisted by many southern states, the amendment's ratification was made a condition for re-entry into the Union. Over time, its scope grew far beyond the post-Civil War context, influencing legal battles on gender equality, LGBTQ+ rights, and immigration. It also played a critical role in the doctrine of incorporation, through which many of the protections of the Bill of Rights became applicable to state governments. The 14th Amendment remains one of the most litigated and interpreted sections of the Constitution, central to the American concept of civil rights and liberties. A&O Shearman has postponed the start date for some of its incoming associates until January, according to a source familiar with the matter speaking to Reuters. The firm typically offers new associates a choice between two start dates and provides a salary advance to those opting for the later one. The decision comes amid broader industry trends of delaying associate onboarding as a cost management strategy in response to uneven client demand, despite overall revenue growth among top firms. Formed through the May 2024 merger of Shearman and Sterling and Allen and Overy, A&O Shearman is now the fourth largest law firm by revenue. While the firm's revenue has benefited from broader sector gains, it faces challenges tied to economic uncertainty and trade tensions. Internally, a cohort of associates had reportedly resisted leadership shortly before the firm joined other legal powerhouses in agreements involving legal services to President Donald Trump, moves seen as efforts to fend off sanctions and settle federal investigations into workplace diversity practices. The firm also experienced a recent exodus in its London office, with 9 lawyers, including 8 associates, departing in June. A New York State appeals court has ruled that social media companies cannot be held legally responsible for the 2022 mass shooting in Buffalo that left 10 people dead. The court reversed a lower court's decision, finding that platforms like Facebook, Instagram, YouTube, and Reddit are shielded by Section 230 of the Federal Communications Decency Act, which grants online platforms immunity from liability for user-generated content. The lawsuit alleged that these platforms were designed to addict and radicalize users, including the shooter, Peyton Gendron. Justice Stephen Lindley, writing for the 3-2 majority, argued that holding platforms liable would threaten the open nature of the internet and contradict Congress's intent to foster innovation and limit government interference. He acknowledged the horrific nature of the shooting and the hateful content that influenced it, but warned that allowing liability would cause the internet to collapse into tightly restricted message boards. Dissenting justices contended that the platforms actively pushed extremist content through targeted algorithms, suggesting that this behavior went beyond neutral hosting. Other platforms used by Gendron, including Amazon, Discord, 4chan, Snap, and Twitch, were also named in the lawsuit. Gendron is currently serving a life sentence without parole after pleading guilty to state charges, and he still faces federal charges that may lead to the death penalty. A federal judge in Massachusetts has reaffirmed a nationwide injunction blocking President Donald Trump's executive order that sought to limit birthright citizenship. Judge Leo Sorokin ruled that only a nationwide halt could fully protect the coalition of 22 Democratic-led states challenging the policy, rejecting arguments from the Trump administration that a narrower ruling would suffice following a recent Supreme Court decision. The executive order, signed on Trump's first day back in office in January, directed federal agencies to deny citizenship to U.S.-born children unless at least one parent was a U.S. citizen or lawful permanent resident. Judge Sorokin found that allowing the policy to take effect even in some states would harm immigrant families and disrupt federal benefits programs like Medicaid. Plaintiffs argued it would create a confusing and unfair patchwork of citizenship rules and overwhelm states not enforcing the order. The Trump administration maintained that the Constitution was being misinterpreted and signaled plans to appeal. Although the Supreme Court recently limited the use of nationwide injunctions, it allowed exceptions under certain conditions, exceptions Sorokin found applicable here. Meanwhile, a separate federal appeals court in California also ruled that Trump's executive order violated the 14th Amendment's citizenship clause and blocked it nationwide. California has dropped plans to require internet service providers, or ISPs, to offer $15 per month broadband plans to low-income residents, following pressure from both the Trump administration and major telecom companies. Assemblymember Tasha Burner, who led the effort, said her office was warned that enforcing such a law could jeopardize California's access to $1.86 billion in federal broadband equity access and deployment, or BEAD, funding. The administration's revised BEAD rules prohibit states from setting explicit or implicit broadband pricing requirements. Despite earlier court wins by New York upholding a similar law, Burner chose to pull the bill after the National Telecommunications and Information Administration, or NTIA, confirmed that even applying for BEAD funds could exempt ISPs from state pricing rules. Advocates and lawmakers criticized the move as a giveaway to large corporations, arguing it undermines efforts to ensure affordable internet access. Burner had already watered down the bill in negotiations with ISPs, reducing required speeds and allowing ISPs to handle eligibility verification, both points that drew backlash from digital equity groups. Advocates argued that BEAD funding was intended for new broadband infrastructure, while the California bill focused on existing networks, meaning the NTIA's restrictions shouldn't apply. Critics also pointed out that the proposed speed standards were below the federal definition of broadband, and that delegating verification to ISPs risked privacy and access issues. While Burner acknowledged the need for affordable broadband, she said the risk of losing billions in federal funds wasn't worth pushing the mandate. A separate Senate bill aims to encourage but not require ISPs to offer low-cost plans by linking them to subsidies. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review in your podcast player, we'd appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the human capacity for burden is like bamboo, far more flexible than you'd ever believe at first glance.